And lastly, I would like to introduce the last speaker, Ms. Miriam Van L. Pereira. Miriam is the Public Relations Officer of the Japan Commercial Arbitration Association. She is a registered foreign lawyer in Japan, licensed in both the Philippines and the state of New York. She's also a counsel at Oh-Ebashi LPC and Partners, and is a member of its international practice group, Corporate and M&A Group, and IB Group. She is involved in cross-border transactions in Asia, the US, and Europe, inbound investment into Japan, as well as international dispute resolution and compliance investigation matters. So would you start, Miriam?
Okay, thank you so much, Mike Sensei, for the introduction. Good afternoon, everyone, and thank you for joining us today. I also would like to thank the sponsors and organizers for the opportunity to be here to discuss some of the key features and developments of international arbitration at the JCAA. And I will also present a case study on interactive arbitration, which is based on a recent case that was administered by the JCAA. So let's begin there. So let's first look at some statistics that indicate the participation of Thai companies in JCAA arbitrations. As you can see from the screen, Thai companies are among the top 5 non-Japanese parties to JCAA international arbitrations, alongside with China, South Korea, Taiwan, and the United States. And next, we have some data on Japan and Thai disputes covering the period from 2011 to 2020. As you can see on the screen, with respect to arbitrator appointments, in 64% of the cases, the arbitrators were non-Japanese. And the language in 64% of the cases was English. With respect to the termination category, in 64% of the cases, they ended or concluded with a final award. I'd like to highlight that in a total of 36%, the parties settled the case, with some of the settlement agreements being recorded in a consent award. This demonstrates the freedom of the parties to engage in settlement discussions or mediations at any point of the proceeding. And the mediation can also be administered by the JCAA under its mediation rules. Another point I'd like to add is that if the parties agree, the arbitrator can also be appointed as the mediator. Now let's look at some of the post-award records of the JCAA covering the period from 2000 to 2020. As mentioned earlier by Abe-san, in the last 10 years, no foreign court has rejected a JCAA award, and that includes Chinese courts, which I'll mention later. So as you can see on the screen, 231 out of 231 final awards, 203 were enforced with no issues. 10 of them were subjected to applications for annulment, most of which were rejected. And 18 of the awards were subjected to applications for enforcement, most of which were granted. In the few isolated cases that involved a JCAA award that was not enforced, these cases occurred more than 10 years ago. More importantly, JCAA awards have been enforced in Thailand, and the JCAA makes every effort to ensure that every award is enforceable. Now let's look at some of the basic features of an international arbitration at the JCAA. So first of all, there's a very diverse pool of arbitrator candidates. So there are more than 400 arbitrator candidates, 2/3 of which are actually non-Japanese arbitrator candidates, and they come from all over the world, more than 50 jurisdictions. And in terms of actual appointments, for the period from 2016 to 2020, 48% of the arbitrators appointed were foreign nationals. The parties have a vast and diverse pool of competent candidates to choose from for their arbitrators, but in any case, they can still select arbitrators who are not listed in the panel. Next, as to the arbitrator appointment process, it is very party-oriented. So where the parties are unable to appoint or agree on an arbitrator, the JCAA will give utmost consideration to their needs. So to illustrate this point, the JCAA sends a list of potential candidates specifically selected by it for the case, after taking into account the parties' inputs, including the ranking of the candidates, the specific expertise or nationality of the candidates, or any other relevant consideration. In making an appointment, the JCAA always tries to select a candidate that would be the most acceptable to the parties, someone whose award will be accepted by them even if the outcome is unfavorable. Now, as to the duration of the proceedings, the JCAA handles a variety of cases, ranging from commercial and licensing transactions to joint ventures and construction disputes. In all of its cases, whatever size, big or small, simple or complex, a speedy resolution is always the objective. As mentioned by Mr. Abbey earlier, the average duration of the proceedings from the arbitrator appointment to the final award is 12.8 months. For smaller disputes or those involving an amount less than 100 million yen, the time for these proceedings is 6.4 months. For disputes within the 100 million range, the 1 billion range, the average time is 14.3 months. And for larger disputes which exceed a billion yen, the average time is 19.2 months. And cases can be resolved even faster using the expedited proceedings of the JCAA. The rules on expedited procedures were recently amended to expand their application to disputes involving 300 million yen or less. To illustrate this procedure, in principle, there's a sole arbitrator who conducts the proceeding based on documents only in general, and he is subject to a time limit for issuing the award. For cases that are 50 million or less, he has to issue the award within 3 months from his appointment. And for those that exceed 50 million up to 300 million, he has to issue the award within 6 months. What's great about these proceedings is that the parties are afforded flexibility to opt out or for higher value disputes to opt in. With respect to logistics, everything you need for an arbitration can be provided by the JCAA. It provides full support for hearings, and it tries to make it easy for the parties to arbitrate, even if they're just beginners. So the JCAA has its own facilities in Tokyo, but in collaboration with the Japan International Dispute Resolution Center, it can also offer the state-of-the-art facilities in Tokyo, which were described earlier by Igaki-sensei. For example, the parties can request the JCAA to arrange for transcription services, court reporter, translators, or interpreters, and the hearing facilities. With respect to remote or online hearings, the JCAA can host the web meetings on its platform at no additional cost to the parties. So the JCAA is a user-friendly and one-stop shop for all your arbitration needs. Now let's turn to the 3 sets of arbitration rules of the JCAA to best meet the needs or preferences of the parties. First, we have the UNCITRAL arbitration rules, which are suitable for companies that are well experienced in international arbitration and which prefer the highest degree of flexibility. These rules are supplemented by the administrative rules for UNCITRAL arbitration, which provide the minimum administrative provisions to facilitate the arbitral proceedings. Then we have the commercial arbitration rules of the JCAA, which are its standard arbitration rules and which adopt global standards and are suitable for any business user in any jurisdiction. These rules include provisions on interim measures, emergency arbitration, multi-party and/or multi-contract arbitrations, tribunal secretaries, mediation, and the expedited arbitration procedures I described earlier. I'd like to highlight some of the provisions. So with respect to emergency arbitration, a party may apply for emergency measures even before the constitution of a tribunal, in which case an emergency arbitrator will be appointed within 2 business days from the JCAA's receipt of the application and the payment of the required fees. The emergency arbitrator will endeavor to make a decision within 2 weeks from his or her appointment. As to multi-party and/or multi-contract arbitrations, these complex cases can be resolved by a single tribunal in a single proceeding if specific requirements are met. As to tribunal secretaries, with respect to their appointment, to better manage the different expectations of the parties, the tribunal is required to obtain the express consent of the parties to the role and remuneration of the tribunal secretary prior to any such appointment. Lastly, we have the very innovative interactive arbitration rules, which aim to facilitate the tribunal's active role and communication with the parties by identifying early on the parties' positions and key disputed issues, and presenting non-binding and preliminary views to the parties on such positions. So these rules were originally available in 2019, and they aim to offer maximum predictability and efficiency in an arbitration. It adopts a more civil law approach, which I think parties in civil law countries like Japan and Thailand will appreciate. Another feature of this type of arbitration is that with respect to the remuneration of the arbitrator, it is fixed based on the amount in dispute. And this makes the total arbitration cost more predictable for the parties. In addition to its arbitration rules, the JCAA has its own mediation rules. Its rules are based mostly on the UNCITRAL model law on international commercial mediation. The rules strictly protect privilege by providing a without prejudice rule and confidentiality to encourage frank and candid settlement discussions. The rules also enhance party autonomy by encouraging the parties to discuss and agree on how to proceed with the mediation. And this can cover as well the method of calculating the mediator's fees. The rules also ensure enforceability of any mediated settlement under the Singapore Convention on Mediation by incorporating certain requirements, such as having the mediated settlement agreement signed by both parties and the mediator, and having the JCAA attest to the mediation agreement resulting from a mediation administered by it. With the recent push toward mediation, we hope to see more mediation cases before the JCAA. And now, here is a hypothetical case study on interactive arbitration, which was based on a recent domestic case, but this could also apply to an international case. This dispute involves a defect in an equipment with multiple components, and the components were manufactured by several companies. The issue is which manufacturer is responsible for the defect. So here we have 5 key steps of interactive arbitration. Let's go through them one by one. So first of all, we start with the request for arbitration, where the claimant seeks to recover damages from, say, company A. And then next, we identify the key positions and key issues. So in this case, the arbitrator will prepare a summary of the parties' positions and key issues for the parties to comment on. This will be done at an early stage of the proceedings. At a later stage of the proceedings, the arbitrator will present or communicate in writing his or her preliminary views, which are non-binding, about the important issues for the parties to comment on. This kind of active interaction between the tribunal and the parties and level of transparency allows the parties to become aware of any misunderstanding on the part of the tribunal. And if there is any such misunderstanding, the parties have an opportunity to quickly correct or clarify that misunderstanding. So with a better sense or understanding of the case, at this point in the proceeding, the parties can choose to move to mediation. So if the parties agree to move to mediation, they can agree also to appoint the arbitrator as the mediator. This dual role on the part of the arbitrator can be very beneficial to the parties if it is done properly. And if the mediation proceedings result in a settlement and the parties reach a settlement, they can proceed to the last step, which is to request the arbitrator to issue a consent award. So this case also features an arb-med-arb kind of proceeding. And we hope that civil law parties will find this kind of approach appealing. And here is a summary of the key features of international arbitration at the JCAA. There's a diverse pool of international arbitrators. Parties are assured party-oriented arbitrator appointments. The rules are flexible and innovative as to time, manner, and costs. The JCAA is a user-friendly one-stop shop for all your arbitration needs. Mediation is always an option, and the awards of the JCAA are enforceable. So for over 70 years, the JCAA has offered ADR services to its users, and it will continue to serve and meet the changing needs of its users based on global standards. So please do consider the JCAA for your future arbitration needs. Here are the contact details of the JCAA for any inquiries. And that concludes my presentation. Hope you found it useful, and thank you so much for listening.